Yes, today I am going to discuss with criminal procedure code. And also this topic is very important one. This topic is related to evidence. But the CRPC under chapter 23, okay? Evidence in inquiries and trials. Under section 272, explain about language of courts. Because this is very important thing. While the evidence taking before the court, the language is important because every state government may determine what shall be for purpose of this court, the language of each court within the state other than the high court, because high court normally English depends upon the jurisdiction of the states. And here section 273 explain about of CRPC evidence to be taken in presence of accused. This is most important because while you are taking any recording of evidence before the court, the section 273 is very important. Why? Because except as otherwise expressly provided, all evidence taken in the course of the trial or other proceeding shall be taken in the presence of the accused, because or when his personal attendance is disposed with in the presence of his pleader, in the presence of the advocate. So CRPC clearly indicated 273 provided that where the evidence of a woman below the age of 18 years, that meaning is minor girl, who is alleged to have been subjected to rape or any other sexual offense is to be recorded, the court may take appropriate measures to ensure that such woman is not confronted by the accused, while at the same time ensuring the right of cross examination of the accused. So, as per these provisions, section 273 of the CRPC explanation is clearly indicated in the sections. The meaning accused. Here, the accused includes a person in relation to whom any proceeding under chapter 8 has been commenced in the CRPC. So let us discuss with the amendment of the Criminal Law Act 2013, which has been inserted before the explanation to section 273 of the CRPC, and empowers the court to take appropriate measures where the victim of rape or such woman is not confronted by the accused at the time of recording her evidence. At the same time, the court will also ensure the right of cross examination of the accused. And another thing, I just wanted to give some differentiate. This section makes it obligatory that evidence for the prosecution and defense should be taken in the presence of the accused. A trial is vitiated by failure to examine the witnesses in the presence of the accused. Mere cross examination in the presence of the accused is not sufficient. And also, in important case law on the observation made by the Supreme Court in Talab Haji Hussain's. In this case, if a fair trial is the main object of the criminal procedure, any threat to the continuance of a fair trial must be immediately arrested if an accused person by his own conduct puts the fair trial into jeopardy. You know the meaning of the jeopardy under the Indian constitution, right? Double jeopardy. No one punished by the law second time, right? It would be the primary and paramount duty of criminal courts to ensure that the risk to the fair trial is removed and criminal courts are allowed to proceed with the trial smoothly and without any interruption or any obstructions. And also in Calcutta High Court has held that an obstreperous accused who renders a fair trial impossible by misbehavior can be expelled from the courtroom. So such kind of expulsion will come within the sanction of section 482 and will not be inconsistent with the provision of the present section under section 317, even though the recording of evidence may take place in his absence. However, the accused can claim his right to be present in the trial on his expression of bona fide willingness to behave properly. And also, I just wanted to explain it clear that word accused includes a person in relation to the whom any proceedings under chapter 8 of the criminal procedure code, that is the proceedings for taking security, for keeping the peace and for good behavior has been recommended or has been commenced. Here, the personal attendance is disposed with a sessions judge has power to dispense with the personal attendance of an accused and to allow him to appear by pleader during the sessions trial. Such a power may properly be exercised in favor of Paradhanisham ladies on the ground of ill health case. Sometimes the evidence by video conferencing, because the accused will not produce before the court because he was in custody in outer jurisdiction of the area, or sometimes due to some complications there. That time the Supreme Court has held that recording of evidence by recording of video conferencing is permissible because the evidence so recorded would fully meet the requirement of under section 273 of the criminal procedure code, and it be as per procedure established by law. So the term presence, the meaning is presence, meaning is in the section does not mean actual physical presence in the court, so has to meet the requirement that evidence must be recorded in the presence of the accused. Okay. Okay, viewers, we'll discuss in this topic in next video. Thank you all. Bye.